ideal of beauty or of goodness. At all times, courts are expected to draw inspiration from consecrated principles. A finding as regards widespread or systematic irregularities is absolutely indispensable for cancelling all the appointments made. For cancellation of the entire examination, there must be as a rule possibility of systemic malice as borne out by materials on record. Assessment of the data does not indicate systemic cheating. It also needs to be mentioned that during the period of service rendered by the appellants, there had been no allegation regarding the integrity or efficiency of those teachers. It is not a case that instructions were given to the examiners to give higher marks, or that the candidates who paid money had been given higher marks in the interview. A group of unsuccessful candidates should not be allowed to damage the entire system, and more so when it cannot be ruled out that innocent teachers would also suffer great ignominy and stigma. The service of the appointees cannot also be terminated only on the basis of an ongoing criminal proceeding. Reliance has been placed upon the charge sheet and supplementary charge sheets by the writ petitioners. In the same, the investigating agency observed categorically that appointment letters were issued upon receiving recommendation letters from the board. Findings arrived at by investigating authority would not reveal that the appointed candidates were involved in any corrupt practices. Upon investigation, it was ascertained by CBI that irregularities exist in respect of 264 candidates who were given grace marks and were identified. Additionally, 96 candidates also did secure qualifying marks were appointed and they were also identified. Subsequently, these 96 candidates were terminated, but they are still continuing service on the strength of order passed by the Honorable Supreme Court. In view of such identification, the allegation of fraud and corruption pertaining to the entire recruitment process is not sustainable. It is the impact of the action that would define the nature of the procedure that is to be adopted. The effect of any direction for re-examination at this stage would have a dissimilar impact upon the appointees. Any such direction for re-examination would fail to secure fair play in action. A job taken away after about 9 years of service would indisputably cause insurmountable inconvenience to the appellants, and their survival along with their family members would be at stake. In such circumstances, and considering the enormity of the impact, we are not inclined to uphold the cancellation of appointment of 32,000 teachers who have worked in the post for a long period. For the reasons as discussed, the judgment impugned is set aside and all the appeals and the connected applications are disposed of.
Grateful, Madam.
But we are paying for stay of operation.